employer messed up the first name and the last name and could not find the amount paid into the 401k pension. What is the remedy?
If an employer has made an administrative error, such as mixing up your first and last name and being unable to account for contributions to your 401k pension plan, here are steps you can take to resolve the issue. Task 1. Notify the employer or plan administrator. Explain the issue. Inform your employer's HR department or the plan administrator, e.g. Fidelity Vanguard, about the error. Provide details such as your name, employee ID, and the contributions in question. Correction. Ask them to update your personal details and locate the contributions using other identifiers, such as your social security number or payroll records. 2. Check your pay stubs. Your pay stubs or payroll records should show deductions for 401k contributions. These records can confirm the amounts deducted and should match what was sent to the 401k account. Provide copies of these pay stubs as evidence. Task 3. Request plan contribution statements. Request a contribution statement from the 401k plan administrator. If your name is incorrect, they might still be able to locate the account using other details, e.g. your social security number. File a formal request for correction. Submit a written request. If verbal communication doesn't resolve the issue, submit a written request to your employer and the plan administrator detailing the error and asking for a timeline for resolution. Ask for a confirmation. Request a confirmation once the name and contribution details are corrected. 5. Escalate to the Department of Labor, DOL. If your employer fails to resolve the issue, file a complaint with the Employee Benefits Security Administration, EBSA, a division of the DOL. The EBSA oversees employer-sponsored retirement plans and can help investigate. Visit www.dol.gov for instructions on filing a complaint. 6. Consult a lawyer or financial advisor. If the issue remains unresolved, consult a lawyer who specializes in employee benefits or a financial advisor for guidance. They can help protect your rights under ERISA, Employee Retirement Income Security Act. Remedies to expect. Correction of records. Your name and account information should be updated to reflect accurate details. Account adjustment. If contributions were misplaced or not allocated, the employer or plan administrator must credit the correct amounts, including any lost earnings. Compliance measures. If errors caused financial harm, the employer may be required to cover any losses incurred due to their mistake. By staying persistent and documenting your communications, you can ensure that the issue is addressed properly.
The employers, namely Michigan Bell and AT&T, contrived plan to show that I quit my job when the undisputed facts showed that I was illegally dismissed by Richard Stone of Michigan Bell and the law firm of Norton Rose of Fulbright and Jaworski by submitting a false and perjured attorney affidavit. The U.S. Supreme Court granted permission to file a writ of mandamus in re. Talacotter, and it was sent by regular first-class mail, which went first to the country of Israel, and from there it went to Germany, and finally reached complainant living in India, and when submitted $300 bank draft made payable to the clerk of the court, it was first rejected by M. Blaylock, alleging the court dismissed the case, and showing a wrong case number 15 to 9100. When David received the same, he forwarded the bank draft to Chief Justice John G. Roberts with a cover letter, and it was submitted to Jeffrey Atkins. Jeffrey Atkins, after correcting the case as 16 to 9624, refused to take, saying the Supreme Court dismissed the case. He was instrumental in returning the papers back to David under different pretext and raising an Article 3 of the Constitution, although his duties were purely to carry out the court's order.
This situation appears to involve a complex series of legal and procedural issues involving multiple parties, including major corporations, law firms, and the U.S. Supreme Court. If your goal is to seek resolution or remedies, here are steps to consider. 1. Understand the legal framework. Wrongful termination. If you were dismissed under false pretenses, your rights may have been violated under employment and labor laws. Depending on the circumstances, you may need to address this through administrative or judicial processes. Supreme Court procedural issues. A writ of mandamus and its handling by the U.S. Supreme Court involves strict procedural rules. If irregularities occurred, these need to be documented for further legal action. 2. Engage qualified legal counsel. Specialized expertise. Hire a lawyer specializing in employment law and constitutional issues. Given the complexity, this is critical to navigating the legal intricacies and ensuring your claims are properly presented. Representation. A lawyer can represent you in communicating with courts, opposing counsel, and any other parties involved, reducing the risk of procedural errors. Document the facts. Maintain evidence. Collect all correspondence, court filings, receipts, and other documentation. Include details of the alleged wrongful termination, procedural errors, and mishandling of your case by court staff. Prepare a timeline. Clearly outline the sequence of events, including dates, actions taken by various parties, and how they impacted your case. 4. Address procedural errors in court. Seek clarification. If court staff acted improperly, e.g. misfiling your case, rejecting submissions, or returning papers without valid grounds, you can request an explanation through formal channels. File a complaint. Submit a complaint to the Supreme Court Clerk's Office or the relevant administrative body overseeing court staff conduct, detailing the errors and their impact on your case. Consider alternative legal avenues. Appeals or refiling. Depending on the procedural status, you may be able to refile your petition or appeal the decision through proper channels. Grievances against attorneys. If you believe opposing counsel committed ethical violations, file a grievance with the State Bar Association governing their conduct. Civil claims. Explore whether a civil claim for damages or injunctive relief is appropriate, especially if you suffered harm due to the alleged actions. 6. International complications. Delivery issues. If critical documents were delayed or misrouted internationally, you may argue that these logistical issues contributed to the improper handling of your case. This could form part of your request for reconsideration. Coordination with local counsel. Engage legal experts familiar with cross-border legal matters, particularly if the case involves parties in multiple jurisdictions. 7. Escalate public awareness. Media or advocacy. If traditional legal avenues fail, raising awareness through media or advocacy groups might bring attention to your case and prompt accountability. Ethical oversight. Advocate for a review of judicial and administrative conduct to ensure fair treatment. Final considerations. This appears to be a highly intricate matter requiring a combination of legal expertise, persistence, and careful documentation. Proceed systematically and seek professional advice to ensure your rights are protected and your claims are effectively presented.
Hi guys, friends and enemies, whoever you are from all over the world, I want to wish you a belated Merry Christmas and a Happy New Year. The purpose of this video is to tell the world at large what is happening in the United States of America. The Congress made good laws, Republicans and Democrats. They are on the statute. So those are the laws which are to be governed by the enforcement agencies. But when it comes to corporations, they always found a way to get off the hook. President Biden was a living example. He said until recently, regardless of the outcome of the investigation against his son, he changed his color. He pardoned his own son. That's the story. He was on drugs. He hid that. He went to buy a gun. It's a compounded offense. Now if a little guy does something, he will be prosecuted and perhaps subjected to hanging or execution. Okay. Why I want to say this is, while the whole world was enjoying the Christmas and the New Year's, I was wasting my time trying to write, trying to codify the things what happened to me during the last 45 years. The reason is the employer who committed major crimes tried to get away. They lost in the Supreme Court, finally. They lost in the Supreme Court of the United States. The Supreme Court finally issued a writ. I'm going to explain what it is. Authorizing the in re Thalakotur in case number 60-9624. Based on the writ, which was transmitted by ordinary mail by the clerk of the court to India, which should have been done by express mail. When I got it, I paid $300 bank draft. You will see the bank draft made payable to the clerk of the court, not a bank check, but bank draft. Once it is issued, it cannot be rejected. The first clerk, M. Blaylock, looked at the wrong case, which was 15-9100. That was not the case the Supreme Court decided in re 169624. That was sent back to me. I forwarded the bank draft with a cover letter to Chief Justice John G. Roberts, requesting him to do the needful. That case went to Jeffrey Atkins, the clerk or deputy clerk of the court. He raised so many objections in not accepting the case. He issued several letters, which we are going to show you, one after the other. In the third letter, he raised an Article 3 of the Constitution. Although his job was purely ministerial, he is not a defendant's counsel. His job was purely ministerial to carry out the Supreme Court's order under Rule 1 of the Supreme Court rules. Now, we kept fighting this case. I didn't say we, I. What happened was, when I was working for Michigan Bell Telephone Company, which is located at 444 Michigan Avenue, Detroit, Michigan, I ran into all kinds of discrimination with the company based on national origin, color of skin, that initially, which led to me filing a complaint with the district court. The district court judge first ruled that the Congress didn't permit us to pay for the cost. So eventually the EEOC came, investigated, found the employer guilty of discrimination. And when I was working, I was found overqualified by my immediate supervisor, Jack Temple, who was remotely watching all of us, especially those who have come from foreign countries. He asked me my background, education, everything, which I explained to him. I had a bachelor's degree from the Delhi University, and I went to study 3 years LLB from the Faculty of Law, Delhi University. And I told him I had worked as a secretary stenographer for the New India Assurance Company. Jack Temple said, Mr. David, you want to take a test? Yes. So I took the test. I passed the same in flying colors. But the company doesn't want to disclose my test result for reasons best known to them. I waited nearly 1 year, and I wrote a letter to the personal officer, one Mr. Shepard. He called me to his office and said, Mr. David, you got a top score in the competitive test, but we can't promote you because you went against the corporation. He refused. Then I was forced to file another charge. When this was going on, my immediate supervisor, which I didn't know at the time, she was the wife of the U.S. Department of Justice, called me to her office and said, Mr. David, would you like to go and work for AT&T? I said yes. They issued me a ticket first class because they have the facilities to issue tickets and everything. I went to work for AT&T for a period of 5 years, subject to extension if parties agreed. While working there, the U.S. Department of Justice and AT&T agreed for the breakup of these companies. There were 22 Bell operator companies or subsidiaries, including Western Union. Everybody was offered 3 years salary, but not to me. They again discriminated, and I was eventually forced to sign a release. You will see the release. I was forced to sign the release under extreme duress, coercion, and true fraud, just to feed my then 4 children, aged 3, 7, 9, and 12. Okay, I was invited to the Royal Plaza Hotel, located in somewhere in Disney World, and Mr. Stone offered me a sum of $45,000 and gave us, me and my wife, who was asked to come to attend the meeting, he fired me after I refused to take the sum of money offered. And there are several tricks here. That's what I wanted to bring it to the attention of the world. When you sign a release under duress, coercion, and through fraud, it is invalid. That was decided by, in 1974, a case called Alexander versus Gardner Denver, 1974. The holding in that case was An employer can obtain a release from an employee if the employee signed the release freely, voluntarily, and knowingly. Knowingly, freely, voluntarily. Three-pronged test. So the defendant deployed tactics. The defendant was represented by an attorney by the name Peter Wolf Sinneber, and he was assisted by a woman by the name Anne C. Conway. The reason is she was previously working for the trial judge John Reed. The purpose was designed to influence the judge through this woman. According to the admissions made by Judge Reed in response to a questionnaire I sent to him consisting of 20 questions, he called me on the phone through his new law clerk. I don't remember his name, a male law clerk. At that time, I was 100 because I was trying to expose the corruption. Judge Reed denied the defendant's motion to dismiss, citing Alexander. Then Judge Reed called a status conference in his chambers, during which nothing was disclosed either by Judge Reed or by Miss Conway, and the meeting ended. Shortly thereafter, he called a second meeting and he called the court reporter and held that there are tribal issues of material facts remains in the case, but no hearing whatsoever was held during the last 45 years. My claims were age discrimination. At the time, I was illegally dismissed by Richard Stone at the Royal Plaza Hotel. I was over the age of 40. You have to understand this. So the age discrimination was there. Termination of my employment was in violation of the IRS Regulation 10.4 and also violation of the Federal Contractor Compliance Program. So all these laws were broken. You understand? Now, the EEOC issued me a right to sue letter. That's how they do. I filed a complaint with the EEOC in Detroit, in Tampa, Florida. They, without interviewing any of the 1,500 employees, concluded that the case would go to Michigan, which has got nothing to do, because when I am working in Florida, why the case goes to Michigan? So Michigan issued a right to sue letter. I sued the company. Okay? Now different tactics were employed. I will give you one by one the tactics. After the judge issued the order, I notified the FBI and Chief Justice Honorable Warren Burger at that time of the Supreme Court. Judge Reed was ordered to resign and he resigned in disgrace. All right? Then what happened was, after Judge Reed recused, the case was transferred to. So, after Judge Reed was forced to resign, the case was transferred to the Defendant's Choice Forum to Tampa before Terrell William Hodges. Hodges, without conducting any hearing whatsoever, issued an order directing the clerk to dismiss the case without prejudice. Without prejudice is a technical term. I didn't know at the time what was the difference between a dismissal without prejudice and a dismissal on the merits. So, Hodges issued the order to dismiss the case based on a test case the defendant Michigan Bell had planted in a state court in Michigan. After the defendants obtained a copy of the per curiam unpublished order without serving me a copy of the same, Hodges ordered the clerk to dismiss the case as without prejudice. Under the scheme, the clerk of the court altered the court's order as a dismissal on the merits. You will see the exhibits. Now, the purpose was to have the case thrown out by the 11th Circuit so that it will end there. It won't go to the US Supreme Court. So, as soon as a panel of 2 judges, namely Stanley Marcus and Edmondson, issued the order, the 11th Circuit issued a The issue that I raised at the time was, how can a panel of 2 judges, pursuant to their local rules, decide something which was not the law of the land? They had no jurisdiction. Okay? That's how the case went on. And once that was done, my counsel had filed, counsel by the name Syriac D. Kaplan of Chicago. He amended the complaint and no trial was held. They tried to bribe Mr. Kaplan by offering him a judicial position at the Cook County in Chicago while I was sitting in his office for consultation. Then the defendants ordered him, or offered him, not ordered, offered him some place, what is called plum cases, so that he can make money. Knowing the defendant's tactics, he refused. my counsel was subsequently murdered. I took over the case and the case went on. So the issue was whether I am entitled to any benefits from my employer. The employer took many stupid arguments. They lost every argument. Then they finally said, we lost the record. And you can send the moon and men to the moon, they can't find my employment record. On November 17, 2023, I went to Atlanta, Georgia, due to flight fatigue for 25 hours, non-stop flight. I got ill. I went to a nursing home. I was taken there by the ambulance chasers because at the time the Democrats wanted the votes from the mules. Okay? And I was not treated. I was kept on a wheelchair for 3 days. That's a long story. Now, the law firm of Fulbright and Jaworski filed a paper, what is called a motion to dismiss, saying that Mr. David quit his job. The evidence shows I didn't quit the job, I was fired by Richard Stone at the Royal Plaza Hotel. And the motion was granted by the Cyber Court of the Eastern District of New York. And the motion was accompanied by a sworn and notarized affidavit signed by Brian Wayne Tilker. I'm going to show you a copy of the affidavit signed by Tilker, testifying his personal knowledge about the same. After I became suspicious, I started digging into Tilker's affidavit, and I learned at the time I signed the release. My investigation showed from the Bar Council record, Tilker was born on XX in the year 1979, and the release was signed in Detroit, Michigan, when Tilker was only 2 years old. You understand? Tactics, employees' tactics. They filed brief justifying Tilker can do so. The Cyber Court justified Tilker can do so while moving for summary judgment. Although he was 2 years old, he had signed a false affidavit. When this was brought to the attention of Cybert of the Eastern District in New York, she said another district court did so, so that is the binding authority, not the Supreme Court of the United States, another district court. What a joke. This case again went, and as I said before, the Supreme Court granted me permission to file a writ of mandamus. You will see a copy of the decision of the reporter. Court reporter, is that what is called a court reporter? Certiorari summary. Certiorari summary disposition. The legal issues I raised were if there is a conflict between the 11th Circuit and the Supreme Court, not the Supreme Court, the 12 other Circuit Court of Appeals, there is a conflict because the 11th Circuit says the decision of a two-judge panel who are retired, and the 12 other Circuit says should be ruled by a panel of 3 active judges. So the Supreme Court had the jurisdiction and they granted. The name of the game is, when you file the papers, the first woman, young Blarocque, returned it. Second one returned it saying, Mr. David, you read my letter and her letter. See the joke? He's saying, read Blarocque's letter, which is wrong, his letter also wrong. Okay? So this is the biggest joke. Now, finally, the employer lost there. The next question is whether I am entitled to my vested pension from the employer. Every year we got a statement when I was a non-management employee and a management employee of AT&T and Michigan Bell. Now, I got a letter from the EBSA saying to contact them. When I called, I got a letter from a woman, what's her name? Jean Breaker. She sent me a special case number and she said she's going on vacation sometime in June 2021.
June 26, 2024.
Okay, all right. And every time we wrote to her, she gave me another case number. You will see. And the last deadline given was December
23, 2024.
2024, right? Right. Today is January 3, 2025. What happened to Jean Breaker's promise? And I believe she will not release the report because it is detrimental to the interest of the Biden administration. As I rightly predicted, Biden administration, breath is lost in the presidential race. And I correctly predicted no woman in America is going to be the president of the United States, although she was the daughter of an Indian person. Now Trump has new players, new games. It will be start beginning on the 6th because Biden has to vacate on 6th of January which is 3 days away from today, and we will see what's going on. If there are any lawyers in America who wants to understand and engage me to take my case over, I'm willing to sign a retainer agreement, either pro bono if they can, or on a contingency fee basis. The amount of money involved, according to my estimate, $500 million. I had served my papers, the Attorney General, the U.S. Department of Justice 3 times, and the defendants AT&T and Michigan by registered mail, and we can track them. Recently, we sent another letter. Nobody will answer the phone. Nobody will respond. My chat GPS says there were 7 companies formed, and which company has my record? Nobody knows. Whom to contact? No way. Is there any way you can get these people on the phone? No way. Okay? Even this morning, I tried to call, and the system will shut you off and no response. So, while the whole world is rejoicing for the Christmas and the New Year, I was breaking my head, studying the tactics. Hope there will be lawyers who will grab my case. I'm sure there will be producers who will take my case for a thriller movie or documentary. They can contact me in India. My email address is trdavid2009@gmail.com. I don't want to give you my phone number because I will have no time to hear all the stories, and they should be, whoever is going to take my case should get a lot of money. I don't want all the money. I may contribute part of my collection to the betterment of humanity, and perhaps set up a law school, either in India, so that the world, we have the brainy kids in this country. Okay? And America should send their people to India to see how our institutions run here. Although I have personal problem with the president and the president of the CDRC Thiruvananthapuram, and also the president of the State Commission, which I don't want to expose everybody now. Thank you. Bye-bye. We have a little bit of problem. It's not created by me, the media, or the spies of the major corporation. I will go into that later. I am not insane yet, although Biden has gone crazy. He doesn't know what he says. He lost before the Michigan electorate, namely communication workers of America and also the auto workers. And as you all know, he pardoned his own son from any crimes. All right, that's the way. But regarding my claims, nothing happened. The chairman of the Democratic Party's Rules Committee, by the name Ralph Curtis Dawson, is the one who directed his former co-counsel Tilker to file a false affidavit. Last week, I found Dawson has been cleared by the disciplinary committee without any explanation. And I filed an appeal to the court as directed. What Tilker did was, he went to Hawaii, the stronghold of the Democratic Party. He got employment in a law firm, which I don't know then. And when I reported to the Bar Council, they alleged Tilker is not licensed. Although he was working there, he directed me to keep asking the disciplinary committee of the New York Bar. Eventually, when I looked his record, I called him on his number. He knows my phone number from the caller ID. He refused. But he took away his license to practice from a law firm, I believe Kyle, whatever the name, and he got licensed to practice before the Supreme Court of the United States. We have it here. We will show you shortly. So, Dawson off the hook. I filed an appeal against him, which is pending. And what I'm forgetting is the game of politics. In the meantime, I wrote to the EBSA, who told me this woman by the name, what's her name? Jean Breaker. She is on vacation, and she will be back shortly. She gave me a number, service request number. Okay. As I told you before, the pension claim of myself was referred to the U.S. Department of Labor, National Contact Center. And a woman by the name Jean Breaker sent a letter to me dated January 11, 2024. Stating they are looking into my claim. That is dated January 11, 2024 at 9:12 p.m. This letter was followed by a letter dated June 26 by the Breaker Jean EBSA, saying that she is out of office until June 2024 with limited access. Then on August 17, 2024 at 2:02 p.m. I got another letter from Jean Breaker, which says, we are USDOL Communication and Customer Service Center. Your inquiry is very important to us, and we hope to provide you with valuable information, referrals, and resources to workplace and labor related topics. This is too small, I can't even see the eyesight with the damn thing. And the next letter was from USBO Central Communication and Customer Service Center, telling me to better assist you, we have opened service request number 044318556 to handle your inquiry. We hope we will review your email and work to contact you with the appropriate resources or immediately resolve your inquiry. Thank you. The U.S. Department of Labor National Center, the contents of the messages are provided as a public service to enhance the public access to the general information on the Department of Labor programs. The accuracy and the timeliness of the information is under regular development, and we review I can't even read the damn thing, and review while we try to maintain the reliability of the general information we present publicly. You should be mindful that you remain responsible for actions you take on the basis of the information. We will make every effort to correct errors brought to our attention. Note, this is a system generated message. Please do not reply to this. That's the next letter. Then I got another letter dated Monday, August 19, 2024 at 12:40 p.m. It says, addressed to me, thank you for contacting the United States Department of Labor National Contact Center. We are the USBOLS Central Communication and Customer Service Center. Your inquiry is very important to us, and we hope to provide you with valuable information, referrals, and resources to workplace and labor related topics. To better assist you, we have opened another service request number, which is 044-322-13 to handle your inquiry. We will review your email and work to connect you with the appropriate resources or immediately resolve your inquiry. Okay? We got a copy of the letter here. This is the next one. Next letter. DOL request number 044-31856 DOL 033. This letter is dated Friday, August 23, 2024 at 6:56 p.m. Which says, thank you, conducting Department of Labor National Contact Center. We have received your inquiry and need additional information to further assist you. please identify the work sector that applies to your inquiry from the options below. Private sector, then federal government sector, UPS, state, local, federal contractor, there are so many sections they are referring. It means the DOL doesn't know where they are groping in the dark. Okay, they don't know what they are talking about. They are talking about the pension the employer has to pay me. Okay? They don't have to grope in the dark. They knew they hit the social security number, it will tell how much money I paid into the damn system. Okay? These suckers, pardon my expression, playing games with the employer. Okay? They are trying to locate my employment records. Anybody who lives in America knows that he or she cannot work there unless you have a green card or citizenship. Right? I'm a citizen of the United States from 1980. I'm a registered Democrat. Okay? So you are telling the same morons, where is my record? They say we don't have it. How they kept me all these years, not only for the employer, Michigan Bell and AT&T, the largest corporations, including the federal government. I worked for the Internal Revenue Service because the employer started blacklisting me, thinking I am possibly a terrorist. That's why Hodges had 3 persons guarding me when I went to a status conference. So these people knew exactly what they are doing. They are trying to fish from the troubled waters, or they make a turmoil so they can say, oh, we didn't do this and this. Okay, so this is the last letter dated I just read to you. That's that one. Now they are coming with another letter. See, they don't know what they are doing. Now they say RO regarding 401k pension from Michigan Bell Telephone Company, Detroit, and from AT&T until I was illegally fired in violation of Title VII, ADA, and other claims. This is dated August 24, Saturday, at 11:38 a.m. on Saturday. Here they say, thank you for contacting the United States Department of Labor National Contact Center. We are the USDOL's Central Communications and Customer Service Center. Your inquiry is very important to us, and we hope to provide you with valuable information, referrals, and resources to workplace and labor-related topics. To assist you, we have opened another service request number, which is 04440803 to handle your inquiry. We will review, email, and work to connect you with the appropriate resources or immediately resolve your inquiry. Thank you. Note, U.S. Department of National Contact Center. The contents of this message are provided as a public service to enhance the public access to general information on Department of Labor program. That's the next letter. Okay? Then I got another letter. This is again 401k pension from Michigan Bell and AT&T payment of monthly pension dishonored by bank details provided by the FPO Manila. What these morons did was they took my name from the my mailing list for pension payments because the day I went there I got ill in Atlanta. I went to the SSA office. They took my details. Instead of sending the money online through the Federal Benefit Unit, they sent a paper check. I presented to my local bank and they wanted like 5 weeks, 6 weeks to clear. Okay? So after this was not even cleared after 1 month, I thought they lost it. So I called the FDU Manila. They stopped the check. Check got bounced. Then they replaced me. Okay? In what you call it, not in rupees, but in bank draft. Now what happened? The bank charged me a fee. The bounce check. Alright? That's that one. Now, after Tilker filed a false attorney affidavit, the case went before the appellate division of the Supreme Court held in the England for the First Judicial Department of the County of New York on June 8, 2012. This was filed on June 8, 2022 at the Supreme Court Appellate Division, First Department. This was unpublished order M2138. This was signed by Richard Andreas, David Friedman, John W. Sweeney Jr., Sally Mansanet Daniels, and Nelson S. Roman. Again, in the matter of an attorney and counselor at law, Departmental Disciplinary Committee for the First Judicial Department petitioner. In this letter, this directed the court to refer the matter to the Brooklyn office. Okay? See, they're afraid of the chairman of the disciplinary committee going to jail. Okay? Big boys, they can always find a loophole. Then I got another letter. This is dated November 1, 2024, personal and confidential, to address to Mr. David R. Talakotu by email only. trdavid2009@gmail.com. Matter of Ralph C. Dawson, Esquire. Docket number 2023-2522. In the letter, it's read. Letter is dated November 1, 2024. Dear Mr. David, Talakotu, we received your recent correspondence regarding the above named attorney. As you know, there is pending litigation concerning allegations which are substantially similar to the material allegations of professional misconduct, and you have alleged here, based on your recent correspondence, it appears that the litigation is ongoing. We have found that a judicial determination of such matters is helpful to the committee, period. Although we have determined to continue to differ. Further investigation man is too small at this time. Further investigation at this time. Please inform us of any court decision or other event which may warrant immediate attention. We will notify you if we determine at a later date to reactivate the investigation. Thank you. Signed by George Dopico, J for George, George Dopico, Chief Attorney. That's all. Now, you have to understand the sequence of events, how the powerful leaders of the Democratic Party getting away. This letter is dated December 5, 2024. Personal and confidential. David R. Talakotu, Mr. David, sent by email only, trdavid2009@gmail.com. Ray, matter of Ralph C. Dawson, Esquire. Docket number 2023-2522, which reads, Dear Mr. Talakotu, we completed our review of your complaint against the above mentioned attorney. As explained below, we have concluded that the investigation or action is warranted. So, folks, the game here is the employee trying to screw you. The United States government don't know where my records are. They don't know. They are groping in the dark. I want the whole civilized people around the globe to laugh at us, Americans, how they are running the Department of Labor. Every time you call, they say, we have more than 50 million people having the problem. It may have by now compounded to 100 million. Everything is beyond the control of the government. The people who wanted to fake, cheat, they can easily get away. And Democrats are no exception. Okay? So, on December 5, is the same letter we got it? December 5 we put it? Yeah, okay. So that's only duplication. So folks, what I wanted to request all of you around the globe, what the heck going on with the US government under the Biden administration, how miserably they lost at the election, and according to my best calculation, the Democrats are not going to come up for the next 100 years. The justices are really and truly worried about their own safety. You understand? The justices, 9 justices. What we should do, what I recommend President Trump administration increase the number of justices to the Supreme Court to 50 rather than 9. The government of India has, my last count, 35 I believe, number of justices in the Supreme Court. I had to check it because there were a lot of appointments coming and going, so that justices appointed to the Supreme Court of the United States will have the necessary skills to examine fraud, waste. The Department of Justice never did the justice to me. They tried to cover up after cover up after cover up. Okay? I hope the world will realize what I am talking. Anybody wanted to make a movie, I can give the script. There are a lot of things which I can't explain in this short video, but those who wanted to make this a thriller movie or a documentary, contact me. My email address is trdavid2009@gmail.com, and give me what your name, your firm name, what role you are calling me. Are you going to represent me either as a pro bono counsel or a contingency fee basis, which I tried. I had one woman who was disbarred from every state except in the Supreme Court. She said she can't do it. Another firm wrote to me to say, to review my papers, she wants $5,000. I can't afford to pay somebody money, and this will never ever end. Okay, guys, girls, any producers wanting to make a movie, they have to sit with me. My leg is having problem. I can't walk. I'm bedridden, literally. Okay? I have the spirit to seek an ounce of justice with a vengeance. And I'm sure the American people should at least write President Trump to do the justice to me. No cover up, nothing. Okay? The law is the law of the land. It is not for one person to get away like Biden's son did. Okay? Thank you, guys. Thank you. Bye-bye.